business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. You may be seated.
Good afternoon. My name is Matthew Carney, President of the Moot Honor Society. And before we begin our final round, I'd just like to welcome everyone to the 11th Annual We the Students National Moot Court Competition and the final round of that competition. Before we begin, I'd like to introduce our distinguished panel of judges for this final round and thank them for coming. Our Chief Justice for today is seated at the center, Judge Kramer, an Associate Judge on the District of Columbia Court of Appeals. She's been a sitting judge since 1984, first in the Superior Court for the District of Columbia and then in the Court of Appeals. She served as Deputy Presiding Judge of the Criminal Division as well as the Presiding Judge. Prior to her time on the bench, she was an attorney at the law firm of Wilmer, Cutler & Pickering and was an Assistant United States Attorney for the District of Columbia, where she was Chief of the Grand Jury Section. On her right is Judge John McCabe, a magistrate judge in the Superior Court for the District of Columbia, where he has served since 2002. A graduate of Duke University and Tulane Law School, he was a staff attorney in the Legal Aid Society for the District of Columbia, as well as Assistant Corporation Counsel for the District of Columbia, what is now the District of Columbia Attorney General's Office. He was also an Assistant United States Attorney with the Office of the United States Attorney for the District of Columbia prior to becoming a judge. Finally, on Judge Kramer's left is Professor Stephen Ramil, a professor at the Washington College of Law. Prior to his career in law, Professor Ramil spent over 20 years as a journalist covering the Supreme Court, first for the Boston Globe and then the Wall Street Journal. He's an expert in First Amendment law as well as the Supreme Court and is one of the founders of the Marshall Brennan program for constitutional literacy in high schools. So please join me in welcoming our distinguished final round panel.
Madam Chief Justice, and may it please the Court. My name is Samuel Johnson, and I represent the petitioner, the Tesla School District in the case at bar. At this time, the petitioner requests to reserve 2 minutes for rebuttal. Thank you, Your Honor. This Court should reverse the Appeals Court decision and grant the school district's motion for summary judgment for the following 2 reasons. First, Ms. Carter's hairstyle was not symbolic speech because it did not convey a particularized message, and because any alleged message did not have a great likelihood of being understood. And second, even if Ms. Carter's hairstyle was symbolic speech, the school acted constitutionally in regulating it under the basis of the fact that it caused material and substantial disruption and because it was advocacy of illegal drug use.
Well, when you say substantial and material disruption, what are you referring to?
Your Honor, if Ms. Carter's hairstyle caused material disruption because of the fact that it led to a disruption in the class when a teacher was attempting to lead to the test and attempting to instruct the students on what they would be doing in the classroom. It also, this disruption went on for several minutes and prevented the other students from understanding what it was that they were supposed to do and forced the teacher to have to send Ms. Carter to the principal's office.
Well, when you say that forced the teacher to send her to the principal's office, isn't that was her choice, but as I understand the facts here and set out in briefs, she wasn't being disruptive. She was simply sitting there with her green hair and coins.
No, Your Honor. In fact, another student was messing with Ms. Carter's hair and causing
yes, that is correct.
time,
But
causing a distraction.
Mr. Johnson, she had dyed her hair about 20 months before the incident in which she was sent to the principal's office. Isn't that an awfully long period of time for the school to suddenly decide that it was disruptive after they'd allowed her to have her hair that way for close to 2 years?
Yes, Your Honor, that would be the case if there were no other factors. However, the record states that there have been several complaints by other teachers about Ms. Carter's hairstyle in the last 6 months. Also, Principal Blake stated that there have been increasing problems with student disruption inside the school over the last period of time, making it so that the school was needing to crack down on student disruption inside the classroom, thereby explaining why the school responded to Ms. Carter's disruptive hairstyle at the time that it did.
But if there was a pattern of disruption, shouldn't the school have been required to tell her? As far as she knows, she was sitting in class about to take an exam, somebody played with her hair for a minute, and all of a sudden she's being expelled. Shouldn't the school have been saying to her all along, your hair is in violation of our policy, and we find it to be disruptive?
No, Your Honor. In fact, the school, she'd already signed the school's policy regarding hair length and requiring that it not be distracted. However, this court should not hold that the mere fact that the school did not previously tell the student, Ms. Carter, that her hairstyle was in violation of policy means that the policy is no longer enforceable.
Wasn't it her purpose in having the green hair to make a point with respect to government spending and how much the government was spending that obviously was more than she thought it should be?
Your Honor, that is certainly what Ms. Carter has claimed, which moves back up to the first issue of whether or not Ms. Carter's speech was symbolic speech. Ms. Carter, however, did not convey a particularized message, failing the first part of the Spence v. Washington test, because of the fact that there was not a single particularized meaning that she was advancing through her style of hair. Because of the fact when she originally spoke with the Principal Blake regarding her suspension, she only stated that she wore her hair in that fashion to express her own individuality and that it was simply a personal choice. Only after the litigation began did Ms. Carter begin claiming that in fact she was protesting federal deficit spending. Furthermore, there are many other meanings which could be reasonably attached to Ms. Carter's hairstyle. For instance, Ms. Carter added the points to her hair in December 2007. It would have been equally reasonable for someone to believe that her message was a protest against materialism during Christmas instead of thinking that she was protesting federal deficit spending.
Does the Spence test require that she produce witnesses who say that they understood her message and that they knew she was conveying a message? Is that her responsibility?
No, Your Honor. The Spence v. Washington test does not require that she bring forth specific witnesses. However, it does require that there be an objective proof that she had intent to convey a particularized message and that that particularized message had a great likelihood of being understood.
Does she have to have something in her hair that spells out what it is? In other words, some of the cases like armbands, draft cars, things like that don't specifically say what the message is, but the Supreme Court has concluded that it was clearly symbolic speech.
No, Your Honor. She doesn't have to have something specific in the hairstyle that would necessarily make someone believe that objectively. However, this court in Spence v. Washington said that it's determined whether or not there's a great likelihood that the message will be understood given the surrounding circumstances. In Spence v. Washington, this court held that since Spence set out his flag, his message was the American flag with a peace symbol over it, directly after the Cambodian invasion and the Penn State tragedy, that the people who viewed that message would reasonably understand it as being a protest of those actions. However,
Mr. Johnson, isn't this really all about whether or not her green hair is connected with the drug problem that the high school has? Isn't that what it's really all about?
Your Honor, that is certainly one of the issues in this case. However, that is not the only issue in this case. If this court holds that Ms. Carter's speech was not symbolic speech, then any issues regarding the Tinker's test, or the Frederick v. Morse test are immaterial to this case. However, if this court does find that Ms. Carter's hairstyle was symbolic speech, then if her hairstyle caused either material and substantial disruption or was reasonably understood as advocacy of illegal drug use, then it would still be regulatable by the school.
Can I ask you about the school's hair policy? I'm concerned that the use of the word distracting, you may not use hair dyes that are distracting, gives the school substantially more discretion than even the Tinker disruption understanding. Suppose that the most popular member of the cheerleading squad had brown hair and came to school one day having dyed her hair blonde, and everybody in the school is talking about how the most popular cheerleader is now a blonde. Would she be ordered to go home and change her hair color because it was distracting?
Your Honor, if the hair dye causes material and substantial disruption, then it should be regulatable by the school district. So yes, Your Honor, if her hairstyle caused a material and substantial disruption, and only if that her specific hair dye caused that disruption.
And here the disruption would be,
Your Honor, the fact that Ms. Carter's hairstyle caused a disturbance inside of the classroom and prevented the normal appropriate.
in other words, someone coming up to her and playing with her hair. Is that what you're saying?
Yes, Your Honor, if other students' actions based on Ms. Carter's hairstyle causes a material and substantial disruption, then it is still.
But is that her call? I mean, somebody walks up to her and runs their fingers through her hair. She didn't invite them to do that.
No, Your Honor, that's not necessarily Ms. Carter's fault. However, that does not affect whether or not the school can regulate the speech. In Tinker v. Des Moines, this court did not add any intent prong to the issue of whether or not a school is able to regulate speech which causes material substantial disruption. And with schools' rights, students' rights are not automatically coextensive to the rights of adults in other settings, as this court held in Bethel v. Frazier. Instead, they must be applied in light of the special circumstances of the school environment. And because of this, any student action which causes a material and substantial disruption is regulatable by the school district. Furthermore, Ms. Carter's hair was also regulatable by the school district on the basis of the fact that it was reasonably perceived as advocacy of drug use.
Let me ask you
Well-
about that, because my understanding is the school had, the principal had expressed a concern about drug use some 2.5 years before, and that's why it seems curious that it took 2.5 years before there was any communication to the student about the possibility of her hair being interpreted as some sort of support of drug deal. In other words, wasn't this policy set out in April of 2007 by the principal and talking about the problems with green hair being associated with drug use?
Yes, Your Honor, that is correct. However, that is not a material fact. And the Sixth Circuit Court of Appeals held in Jackson v. Doria that even though a school in that case declined to regulate students' hair, which was in violation of the school hair policy, for